slides here. I can't see my face, so if I'm making funny faces, like I said, or looking to the side, or look like I'm looking at nothing, that's why. But hopefully this works well, and you can see everything well. Real privileged to be here with you all today to talk about something very, very important, right? And something that is very much upon us. I can't see your faces and all your names, but I know so many of you and have had the really great fortune to work with so many of you over the years. And great to be back with you here again. I'll mention in just a minute, I haven't been in the space as much recently. I had some kind of changes in my professional life that I'll mention as relates to what we're doing here today. But first, I want to say before I dive in, and you may have heard me say this before, but I really mean it, and I always like to remind ourselves of it. One, I just like to, before we dive in, I like to take a minute to center and remind ourselves of just the sheer importance of what we're doing here. Like, we get very focused on compliance, rightfully so, we have to do that, but let's not forget that there's a very human element of what we're doing here. You know, we're talking about grievance procedures that relate to difficult times in the lives of people in your communities. And so I just like to just remind ourselves of that. And with that, I like to also say it's a true privilege to be with you all. I always say that when I speak with Title IX professionals, I know multiple things right off the bat without even knowing people personally. I know, one, that you're someone that your institution trusts with very, very important subject matter. Two, I know that you're someone who cares about important things in an unselfish way, because none of you are just a Title IX professional. Probably you are all wearing other hats on top of that, and you're stretched thin, and you're still stepping up to do this. And three, and I don't say this lightly, you're brave. I mean, this is daunting subject matter. We've been chasing around the regulatory changes the last few years. This is difficult stuff. It's intense subject matter, and you're here wading into it. So from that standpoint, it's a real privilege for me to be with you all. And it's my sincere hope that I can say some things today that will be useful in this important time. Let me give you a super quick update on kind of where I've been, and then I'll segue that into our subject matter. So most of you all that I've worked with, I've probably worked with from a larger law firm. I was with McGuire Woods and Parker Poe and then Jackson Lewis. Really appreciate the experiences I had there. They brought me to this group and so many other wonderful clients. But I felt really stretched thin in the big law setting. I felt like I wasn't able to diversify my time, what I spend my time on. And frankly, I felt like I wasn't always able to give my work for you all the depth that I wanted, because there was just so many production demands. So I took a leap of faith about start of 2023, started my own law firm, started a business in Panama, started chasing my literary and film dreams. I'm a poet and a film producer, and really diversified my time. But the important thing is I started relating to my legal practice differently. And so now I practice less, basically part-time, but I am able to focus more. So I'm able to bring more of me to the matters that I choose to take on. And I say that's relevant here because what we're talking about today is kind of the end of a personal quest for me. I've been in this space for a long while, caring a lot about trying to put people in positions for success in their roles and your roles as Title IX professionals, and feeling like as an industry, we've been falling short. And you all know what I'm talking about here. We've been trying so hard just to catch up with the latest regs and be in compliance that it's been very tough, despite all your best efforts, despite our best efforts, to get the depth of level of training we need to get the model of grievance procedures worked out so we can really deliver quality. And I've long been thinking, hey, here's an opportunity. When these new regs drop in 2024, I'm going to have less on me. I'm going to be more centered. I'm going to have time to really study this and try to figure out what is the model. And the model drives everything. What is the grievance procedure model of all the options that puts you all, especially institutions with limited and stretched resources, in positions for success? Because I frankly am kind of tired of us being in the industry and, despite our best efforts, not quite getting to full quality, right? And not getting to a place where we feel really comfortable in our role. So what is the model that allows us to do that? And that's what we're going to dive in today. I'm going to be pretty singularly focused on grievance procedure models, pros and cons, options, and then I'm going to make a strong recommendation. And I'll mention this early, and then I'll jump into the subject matter. I've had the chance to study these regs and the related commentary for dozens of hours, and I've drafted a set of policies and procedures that I have available. I mention it just because I think it's relevant here, that I have available, that multiple community colleges are already using, that more than 25 schools in total are using. And I'm going to say humbly but forcefully, I think it's the best option available out there. humbly because I'm not trying to puff myself up with that, forcefully because this matters. You all are looking for options, you're looking for answers. And so I'm going to shoot you straight. This is a model that works, and it works with limited resources too. I'll say more about that, but now I want to get into more of like the philosophy behind it. What is the analysis of why I land on a recommendation for a certain model versus another model? What are the resources around that? So here's a little roadmap to how I'm going to try to approach this today. I want to start with just a couple quotes that I find inspirational from philosophers and relevant to this, and then we're going to dive into just a very quick overview of like that. What are the most major shifts? What are the headlines? What are the highlights of the Title IX regs? And use that as a setup to get into what I really think is the most important question and call, which is now that we've had, we had the 2011 swing, the 2014 swing, the 2020 swing, the 2024 swing. Now that the dust is settled on all of that, which grievance procedure model should you all be using? Should we be using of the many options? And I won't hide the ball here. I'm going to make a recommendation on this, what I say is the most important call. And I'm coining what I think is a new phrase here, but I hope and believe it'll catch on. I'm going to suggest a single initial investigator decision maker plus model. That's a mouthful. But it all means something, and I'll unpack that. And I think that's the one that puts us in a position for success. It has enough process to pass muster and to be fair, but it's lean and it's efficient, and it leads to efficiencies, and it leads to more quality. Let me just share a couple quotes that I love and think are relevant here. I won't read them. I'll let you read them. But this is the great Austrian philosopher writer Viktor Frankl. And I love this quote. I think it's so empowering, and it really points us to where our opportunities are in the midst of challenge. And I think it's relevant to right now. We've been working with these regulatory changes
Excuse
for a while.
me, Josh.
Yeah.
Your slides are not advancing.
Oh gosh, that's no good.
Yeah,
that is no
you need to advance. There you go.
What about now?
Now we can see it. Stimulus, space, and response.
Okay. Does it look okay? Because I had it from beginning on the slideshow, but I guess that's not working. So this is good?
Yeah, that's fine. As long as you just keep advancing.
Yeah, cool. Thank you, Trudy. I appreciate it. Let me know if anything else. Let me go back here then. If it didn't advance, let me just show the roadmap for a quick second, because I was probably just talking and you weren't seeing it, but just take a second to peek at that. That'll give you a sense of where we're headed. So yeah, I mean, what's the stimulus here is that we've got another new set of regulations, and our response is what we do in terms of how we revamp grievance procedures and policies, and then everything that flows from that. And in that space, we have an opportunity to really take control of this and to say, okay, we've been working at this a long time, but how do we get even better at it? How do we put ourselves in a position for success? And I love this. I'm not going to read this one either. I'm going to leave you to read it, but this is from the great Stoic philosopher Epictetus. And I love what he says here. Well, I remember when I read it, it just smacked me down. It just struck me so hard, because he's talking here about the quality of our attention and our action. And I think this matters here because, again, I think we rightfully so and understandably so, in this space, we've been in a very results-driven mode, right? We've been like, we've got to get something compliant down and just have it there. And then if something comes up, we've got to get to the end of this investigation and hearing. We've got to make a decision, and all that's necessary. But we haven't maybe had the time to stop and think about how we're doing it, and how is this set up in the best possible way to start with. And so I think we've got an opportunity here to pay more attention to that, especially with regard to this most important question of which model are you using. Let's did that advance, Trudy? Are you on 2024 Title IX regs?
Yep, you are. Yes, you are at the highlights, most major shifts.
Wonderful. And if I jump out of the frame somehow, you'll let me know, I'm sure. But so what are you've probably seen a lot of this. You all have been following this. You've been reading blurbs. You've probably done some other trainings and webinars. But let me just hit again. What are the big highlights here? How did this shift? And let me just remind us all. We probably needs no reminder, because this date is probably all over us right now. But August 1st is when we have to have our significantly revised policies and procedures in place. Have a plan for training, and the regs are binding on that day. It's approaching quickly. So what happened here with these new 2024 regs? Well, a lot, but here are the highlights. The biggest thing is a massive, probably doesn't get it, a re-expansion of the scope of what falls under Title IX grievance procedures. I list multiple ways that it expanded, and these aren't even all of them, but just to call out some, the prohibited conduct definitions got bigger and more expansive. Again, they cover more types of behaviors by a lot. The geography, the places where a Title IX grievance procedure requirement kicks in, expanded. So those two things kind of multiply by each other for a big expansion. There's much less formality under the new regs in terms of what constitutes a complaint and what triggers a requirement that you all respond to a complaint using the grievance procedures. And there are other factors. All of this combines to make it highly likely that there's going to be a spike and a multiplication of the allegations that are covered under grievance procedures. I mean, if it goes how it seems like it would, you will be busier than you've been before. You will have a bigger caseload because more is going to fall under these grievance procedures by a lot, as I said. Add to that and I don't mean to be the bearer of bad news. I don't mean to be a fearmonger, but this is real. A significant expansion of the Title IX coordinator roles. Title IX coordinators on your campus need more support and resources than ever. Not only is it this expansion of what the grievance procedures apply to, not only is it a revamping of the grievance procedures to meet with the new regs, there are new categories or expanded categories of responsibility around providing support to pregnant students that falls on the Title IX coordinator's plate, around gosh, I'm drawing a little bit of a blank here. Oh, around any barriers to reporting, studying that, around training requirements have expanded quite a bit. Reporting is re-expanded. So there's a lot on the Title IX coordinator's plate. And all of that makes the last point here, the last highlight I'll call out, very interesting, because now they've removed the live hearing requirement. A school still could have a live hearing if they want it. And we'll talk about the pros and cons, but it's not required anymore. And that's coupled with this kind of explicit blessing, not kind of, an explicit blessing from OCR of what we've known as the single investigator decision maker model. And that's always been kind of, everybody's always been like, is this okay with OCR? Is this not okay? They came out and said, it's okay for us. There might be other reasons that it's not, but for us, we're okay with it. So that puts us in the space of saying, I'm going to go ahead and give a preview of the next slide. I'm going to talk about why this is such an important call, which model you're going to use. You can't just use any model. This is going to drive a lot of things. But think about the fact that you've got expanded, busier than ever, Title IX coordinator with more responsibilities. Gosh, let's pay really close attention to how we set up these grievance procedures so that we're doing what's necessary, but we're being lean and efficient about it within these new demands. And that leads us to this most important question and call, which after all the shifts, after the new regs, after the dust is settled, after the experiences we've had with whatever models we've used before, where do we go now? Which grievance procedure model now? What are the major possibilities? And this will be a review for almost all of you, but let's just call it out to kind of set the table for the discussion. There are kind of three kind of major ones along the spectrum. And then I'll go ahead and say on number 4, there's a lot of in between hybrid variations. But one option is kind of the most pure single investigator decision maker model, where one person is really kind of judge and jury, and in the most pure version of that model, there's not even an appeal. So that's kind of one end of the spectrum, very lean, not as much process. I'll get into pros and cons in a minute, but that's over here. Then kind of further down the spectrum, you have a handoff to decision maker model, where there's at least there's an investigation as always, but there's at least one other person that gets it, the results of the investigation, and that other person or panel makes the decision, about responsibility or not, sanctions or not. Sometimes there's an appeal with that, sometimes not. That's a non-live hearing thing. And then on the furthest end of the spectrum, in terms of amount of process, there's live hearing, which again was mandated under the 2020 regulations, but is not anymore. So we think about whether it makes sense or not. And then there's many in between hybrid variations. What I'm going to recommend is going to be a hybrid variation that's really, basically it's between 1 and 2 and skips most of 3, the live hearing, and I'll get to that. Why am I harping on this so much? Why is this quest for me to find the model that I think works best for the North Carolina community college system? Well, in my mind, the model drives everything about how this goes from here. And I'll just call out some things here. Think about these 2 ends of the spectrum. Think about like single investigator on one end of the spectrum versus hearing on the other end, and everything that's in between. Wherever you land there makes a lot of waves around resource allocation, resource decisions. How do you staff your team? How many people do you need to train up? How often they're going to be called into action? How many different roles are going to need to be assigned? How often are you going to need to bring in someone from outside to do it? Drives all of that. All of that turns on the model that you pick. And that's not even the only thing that's resource. It's a resource heavy decision or resource impactful decision, but also it's going to drive the quality. One of the things I'm going to talk about here is let's get really honest with ourselves, me included, all of us included, about what we can do, what we can pull off. Do we have a model that's really feasible for our team? Certainly, we're not going to do less than is required. We're going to step up to the plate, but do we have a model that's practical that our people can step into and say, I can do this. I can do this in a quality way. Or are we in a space where we're not able to do that? That's determined by the model. Heavy impact on the party and witness and other participant experience. Again, it's not hard to see how kind of one end of the spectrum versus the other end of the spectrum would be different on the person participating in terms of layers, in terms of amount of time, in terms of impact on telling the story, how many times, that type of thing. And then finally, whatever we choose, it's got to withstand the potential for criticism. Someone's going to second guess it. Someone's going to say that's too much, that's not enough. So we've got to be really careful and informed and nuanced around balancing these and many other factors. This is not a light decision. This is going to drive everything about how Title IX goes on your campuses kind of going forward until the next change of the regulations. So let's look at those three major options and unpack some pros and cons, and then I'll make a recommendation for you. Pure single investigator decision maker model. And again, in its purest form, it has no appeal. Well, what are some of the pros? I'm not going to read every single one, so kind of read along with me, but I'll hit the high points here in the interest of time. It's very efficient, right? It's straightforward. One person does an investigation, one person makes the decision, one person hands off the decision. This is about as lean as it gets. I tend to think that this is something that I'll say a few times, but I tend to think when we have leaner teams of people who are more heavily trained, when we need less people, to be trained up, we can go for depth and breadth of training and experience. And I tend to think that could lead to an increase in quality, lean staffing. And this is something that reasonable minds can differ on, whether it makes you a better decision maker to have done the investigation, or whether it makes you an inferior or potentially a biased decision maker. I'm going to take a stance on that. I have come to believe that it makes you a better decision maker. I think there are ways that we can protect against bias. We can train around bias. And having had that depth of digging in versus just having something handed off to you and having to study it and then make a decision, I think there are benefits there. Reasonable minds can differ. The cons around this one are, is there enough process? And I'll just come out and say probably no. Probably on this most lean, pure single investigator decision maker model, especially for public institutions like you all who have a little bit more requirement than private institutions in terms of due process, it probably doesn't get there. There's not enough layers. Some courts have even said it doesn't get there. But I do think, and that's because there's some potential for bias. There's some kind of perception that that's not enough process, and that influences how courts and others see it. OCR has blessed this, but I'm going to come out and say that I don't believe in its purest form it's an option for you all. It's the right option. But with a few tweaks and a few additions that I'll talk about, we can tap into the pros of this model and kind of mitigate against the cons and get a really efficient and fulsome enough approach, I believe. Second model is this handoff to decision maker model without a live hearing. There are some pros here, but potential pros. You add a layer of process. You separate the decision maker from the investigation. Again, I would argue that maybe that's not worth the whatever benefit you get because they have to come to it cold and they might not get the depth of understanding of the facts. But others would say that that's a good thing. So there's some pros here. It's kind of this in-between option. It's not as lean as single investigator. It's not as straightforward or efficient. And again, I wonder, with adding a whole other layer of process, I wonder how much we really gain there. Now we have to staff up another position. Now we have the separation of investigation from decision maker. I think that there's a better way to get to another layer of process that doesn't involve the handoff. And so that's why I land kind of in between these two. And then live hearing, and I'm going to get a little opinionated here. I mean, I've been working in this space a lot and I care about it a lot. I I hate to make a blanket statement because there are those exceptions where the live hearing probably at some institutions has they have the resources to do it. They have the culture of doing hearings. They've been able to do it in a meaningful way. There are probably those instances out there. I think it's, you know, it's ambitious. It's probably, it was well intentioned. The intention was to give plenty of process, but I'm going to step out and say, I think on net and on the whole, it's been a failure in higher ed. I don't think the live hearing is the right thing for this space. And there are a few reasons for that. One is I just haven't seen it done very well, maybe ever or very often. And that's no disparagement to the people doing it. That's no disparagement to you all boots on the ground. That's a disparagement to the fact that it's really cumbersome. It's really complex. There's really a lot about this not intuitive. I've spent a lot of years of my life in court and in mediations and those types of things. I've waited and so presumably I would feel comfortable in this type of setting. I personally have waded into roles in live hearings where I've said, my gosh, this is tricky. There's a lot that's being asked here. And oh, by the way, it's being asked of you all who aren't necessarily doing this every single day, right? You're coming to it after maybe some time off from it. You know, you maybe haven't had the full depth and breadth of training that you like for this type of role. I think it's been a failure. I think it's a bad idea on net. I think it also overshoots the mark. You know, I like process and I like fairness, but we make a lot of really important decisions in higher ed that we don't have live hearings around, right? There are other ways to get to the facts and put ourselves in a position to make a decision. And the last thing I'll soapbox about, and I'll switch to my recommendation, but I feel very strongly about this, is it is so, I said here, intensely resource intensive. I don't even know that's like a correct phrase, but I wanted to say it that way to just hammer it home. I mean, my gosh, you know, what we have to bring to bear in terms of trained up people or bringing in someone from the outside to try to pull off a live hearing. I just think it makes the team too big and necessarily, and I think it makes this training too shallow because we have stretched resources. So I'm going to argue really strongly for a shift in how we staff our teams. This is part of why I move away from the live hearing model, even though it's still a possibility. I'm going to argue, and you know, hear me on this if you don't hear much else today. I think this is a really critically important point. I would strongly suggest that you relook at your Title IX teams. And this is no disparagement to anybody. We've all been learning this as we went, and I've changed my thinking around it a little bit too. But if you have 10, 12, 13, 16 people on your Title IX team, you know, all these people, I would suggest leaning that down. I would suggest getting, especially if you adopt the type of model I'm talking about, where you can have 3, 4, 5, 6 people, enough to deal with conflicts, enough to deal with allegations of bias and stuff, enough that you can staff, but a really lean team. This is how we do other things, right? We don't have 100 people we don't have 20 people dealing with disability accommodations. That's complex. But we have a few people that are heavily and deeply trained and are in a position for success. So I would argue for a team of what I call Swiss Army knives, a team of people who are steeped in this, who have their minds around it a lot, who get real depth and breadth of training, who are trained for all the roles and can really step into any role at any time. And I've seen this work really well, and I've seen it work in the community college system very well. I don't know if they're on here today, and I haven't planned to do this, but and there are other examples, but I've worked with Wilkes Community College a lot. I'll call Scott and Kim and those folks out if they're on. They do this beautifully. They have a really close-knit team, and I've had calls with them where we're talking about intense things, and just the level of knowledge that's there, the level of comfortability is really strong, as opposed to putting out a team there again of 10, 12, 13, 14 people. And for as much as they might have the best intentions and do their very best, 8, 9, 10 of those people don't have a real chance, you know, of stepping in and playing a quality role because they just don't have the time and the exposure. I've probably soapboxed on that enough. I feel very strongly about it. I think it's a key to conserving resources and still doing this very well. So all of that, kind of weighing those pros and cons, leads me to my recommendation for what I think is the best model for everyone in the higher ed industry, but especially I like it for community colleges because I know that you all do a tremendously great job with limited resources often. And I'm thinking about those resource challenges. So I'm calling it the single initial investigator decision maker plus. Maybe someone can help me come up with a more succinct name for that, but that's what we're with for right now. Look with me at this first bullet. What do I mean by the plus? These aren't just random pluses. These are three things that I think we can add to the single investigator decision maker model to shore it up against any cons and criticism, and to make it have enough process but still be very lean and efficient. Those three things are a robust ability to challenge the appointment of the person who is the initial investigator decision maker. You know, let's put it right out there out front and say, hey, if you have any qualms about who this person's doing a lot here. If you have any qualms about, bring it to us. We'll see if we believe that there's bias, the Title IX coordinator. If so, we'll make a change. But that robust ability to challenge is important. A robust ability to review and provide evidence, even within the single initial investigator decision maker. Within that investigation process, there can be an ability for the parties to review the evidence, to respond to the evidence, to suggest proposed questions. So they're getting process, they're getting fairness, but we're doing it in a lean way. And then finally, I think an appeal right is very, very important. And this is where I've tried to, this is not the handoff model where we do investigation, decision, and maybe appeal or maybe not. I like investigation and decision here, and then hand it off for a second look as makes sense on the appeal. And I think there's a lot of protection in that. So it really becomes an in-between, like I said, between the traditional pure single investigator decision maker and that handoff without a live hearing. And in my mind, and just factually, I've studied this a lot. I've given this a lot of thought, really thinking about you all, really trying to say, okay, what's going to put us in a position for success? Maybe there's no perfect solution, but I think that this approach captures and enhances the pros of those first two models and mitigates against the cons of those models, and avoids altogether this live hearing complexity and all the downsides that I talked about before with the live hearing, which I'm really not a fan of at the end of the day. How are we doing with time? I don't have a lot more. I'm going to run through what little additional bit I have, and then we can open it up for questions if you all like. So, but that's the model I like. Let me just say then, just think with me for a minute conceptually about how this would work, just kind of start to finish. Under this type of model, the Title IX coordinator still does intake and deals with the potential for dismissal and figuring out whether the scope applies, then appoints an investigator / initial decision maker, gives the parties a chance to challenge that. The investigation moves forward. Within the investigation, there's an opportunity to review evidence, to weigh in on evidence. And then there's a decision made by that first person who's been close to the facts and talking to the people, which again, I think is a benefit. And they will have been trained, because we're going to have a smaller, leaner team. They're going to have more anti-bias training than ever, more thinking about how to operate in that heavy role without being biased in any way. And then there's a handoff for an appeal, right? And then after the appeal, or the appeal gives the chance for kind of the second look on that. So that's, and never a hearing in there, but plenty of chances to ask questions and gather and consider evidence. That's what I'm suggesting, excuse me. So suggested next steps and resources. I mean, if you have not already, I would say, even if you have, if this brings any new considerations to mind, there are still a few weeks. Carefully consider these options. Think about what type of model you all want to be rocking with going forward. Think about all the implications of that model. Make a firm decision, firm and informed decision. I'm going to suggest that you find a reasonably priced flat fee model that you're comfortable with, and ideally that's being used by multiple other North Carolina, sorry, I'm missing a C there, NCC, N3Cs institutions. Now, I do think that there's, at the margins, there's probably some benefit in the fact in different institutions across the system using slightly different models so they can learn from each other. But I think there's heavy benefit in, if you find something that works, multiple schools doing that, because then you can compare notes, maybe even share resources, fine tune and hone together. So find that. And I say reasonably priced, and I'm not going to, there are a lot of service providers in this space, but there are a lot of efficiencies here too. I'll just tell you, think about this. I mean, if you got someone who wants to charge you $5,000+, $10,000+ for a policy and procedure. I mean, this is important stuff, but I think it's worth asking them, what are your margins like here? You know, don't you just do this and then you kind of sell it over and over? And is it really necessary for you to charge me in the tens or the teens for that? You have to make those decisions. But I think that you should be looking for not the cheapest option, because this is important and you pay for what you get sometimes, but look for a reasonably priced flat fee model that's mostly plug and play with you know, whatever kind of blanks you need to fill in. I'm going to say this again, just one more time. I'm not trying to push this on anyone. I want it to be out there in a forceful way, because I think I've created a really great option here. You can read this third bullet. I won't go fully into it, but it is what it says there. I have a really good option available. I have it available for a great price. Multiple institutions have already used it in your system. They've gotten it approved by the board. It's been plug and play. They're sitting there, as far as I know, based on the feedback I've heard, ready to rock and roll. You know, they've got a model in place that they feel good about. It's approved by the board, and now they can get to the training and other things. So I think it's a really strong option. And you can also check with other regional and national, you know, law firms and Title IX service providers. There's a lot of options out there besides what I'm doing, but I feel really good about what we're offering, and it's been put together very thoughtfully. And it follows basically to a T, as it would, you know, the model that I talked about in detail, that I think is our kind of our best approach here. So it's process. It's got process, but it's efficient process. So I'll just end by saying, and before we open it up to any questions, oops, I didn't mean to do that. You know, reach out if you want. I mean, I'm here. If you're interested in anything that I said, if you're interested in the option, we can have a no pressure conversation. I can answer questions. We can see if it's fit for you. I can provide references of your colleagues in the system who are using this if you want. If it's a fit, so be it. And if it's not, hopefully I can help point you to the right fit for you, because I know a lot of people in the space, and ultimately I just want what's best for you all on this kind of daunting decision that you have in front of you. Here's my contact information. I'll make this available with Trudy as well. And you know, even if you already have something locked in, if you want to, let's have a conversation, because I'm going to have it priced so low that it might be a good supplement even in that position. So whatever works for you. With that, I'm going to stop, and it's probably good timing. We're 35 minutes in, and we've covered a lot of ground. Trudy, I'm going to stop and take my slides off, and if folks have questions, we can dive into them. If not, that's fine too. Does that work?
Works perfect.
Right.
So yeah, go ahead and take them off. And at this point, if anybody has any questions, go ahead and unmute yourself. You don't have to put your camera on, but you can if you'd like. We'd love to see your beautiful faces. But now would be a great time to ask Josh some questions, or if you needed clarity on a point that he made today. So now's the time. So I'm going to hand it over to everybody, and go ahead and unmute yourself if you have a question.
Hi, Josh.
Trudy,
this is Cindy Dean. I'm sorry. Go ahead.
Oh, hey, Cindy. Great to hear your voice. I don't see you yet. I'm trying to get out of this. Trying to get out of the screen. Can you stop me from sharing, Trudy? I'm technologically challenged here, and all I want to see folks if I can, and I don't want to close it out.
Okay. You are no longer sharing.
Okay, wonderful. Oh, great. I see you all. Hey, Cindy, how are you?
Hey, I need a little bit of clarification on the handoff. You mentioned handoff for an appeal. So that's if either party appeals, then you bring in a third party to adjudicate that, rather than having the original investigator decision maker do it. Is that correct? Or is this somebody to look over the initial decision before it even goes out to the parties?
Great and nuanced and great and dead on question, Cindy. I really appreciate it, because this is key, and it's just different by degrees. It's the first, what you said. So as opposed to kind of the investigator just handing it off either with a recommendation or not, and then someone making an initial decision, and then there's either an appeal or not. It's not that. It's what you said first. It's the investigator looking at all the facts they've dug into, or team. Sometimes it's two people, right? Making a decision, and then to your point, if the parties appeal, and there's limited grounds on which they can appeal under the regs, it's not just a willy-nilly re-review, but if they appeal and they appeal on the right grounds, which we have to allow them to do, then that second person gets involved. It's a different person, and then they look back over it. It's that.
Okay.
So,
Thank
yeah.
you.
And you know, someone might say, gosh, that sounds a lot like the handoff model. But again, I think the devil's in the details here. I think I like the person who was closest to it making the initial decision about it, and then a look off, as opposed to the first handoff before the decision.
I agree. I like this model. Like you said, it's leaner, more efficient, and it still gets another person's eyes on it if there is an issue with it.
That's right. You got
All right.
it.
Thank you.
Of course. Nice to see you. What other questions? And you can go more broad too if you want. I mean, this is open time. If there's something other than the model you want to talk about, I'll do my best. And if I know the answer, I'll come back to you.
Hey Josh, it's Kim. Thanks for the compliment to Willis Community College. As
Of
you
course.
know, we've used both models. You know, we used to do more of the single, and then we split everything out in the process. And I must tell you, it takes much longer and it's much more complicated once we split it out and did all the handoffs. So I'm glad to hear that we're having permission to rethink that.
I'm glad that hits you well. Good to see you, Kim, and the shout out's well deserved. And I agree. It's just where can we condense? Where can we make life a little easier and do what we need to do?
Correct, because to your point, probably every person on this call is a Title IX person plus 5 other things. And so we don't have any just pure Title IX people. And so,
Yep.
Yes.
Good point. Great point. Thanks for weighing in on that, Kim. I'm glad you feel that way about the model. And nice to see you. It's been a while.
You too.
Any other questions, thoughts? Again, even more broadly about the new regs, even if it's something I didn't hit on all the way.
If you're not comfortable taking your camera off or unmuting, you can certainly type anything in the chat as well. I'm monitoring the chat, so you can also put your questions there.
I'll ask another question, Josh. You know, when we've been studying, there's kind of seems to be 2 parts now, like depending on who's in the mix, and if it's student on student, if it's employee on employee, if it's employee and student, and there seems to be different directions. Would you recommend the same model regardless of who's involved, or is this you thinking primarily when it's student against student?
So it's a really great question, Kim. I mean, and just to highlight it, everyone probably already knows because they've been studying it, but just to put an even finer point on that, what Kim's referring to is the fact that in the new regs, we have kind of new definitions, new terms, right? So the big ones are sex discrimination is kind of a general term, and then more specific within that, sex-based harassment, all caps, right? Which would be more like a lot like what we were calling Title IX, sexual harassment under the previous regs. And then further to her point, and here's some complexity, there's different requirements based on who are the parties. So if there's a student who's a party to sex-based harassment, then there's a little bit more stringent requirements about like written notification, things like that, than if we're talking about just general sex discrimination, or if we're talking about something where a student is involved. So your question's a great one, and I think it's actually another argument for this model in my mind that I didn't even hit on, which is I think it's nice to use the same model so that mostly you're doing the same types of things. And it's really important to have a lean model, especially on that sex discrimination piece, because everyone who's looked at it knows how broad that is and how broad the reporting requirement is. You could have a lot of those. So you don't want to be doing hearings all the time on that broad thing. It's nice to use a lean model for both, But then Kim or anyone who looked at, like, for example, the model that we drafted, what you'll see is you'll look at these two parts and you'll be like, gosh, are these the same? But there's a couple key pieces in the sex-based harassment involving students that are different. So you got the same basic model, but for example, you're using this single initial investigator decision maker plus model for both. But within the broader one, for example, written notice of allegations is not required. Notice of allegations is, but in the sex-based harassment involving students, written notice of allegations is required. So because it gets so nuanced, I like having the same model where you can just pick out a few differences rather than doing like single investigator plus over here and live hearing over here. For me, that gets very complex.
Thanks.
Josh, you have another question. It's can you talk about how colleges will handle the separation of employee complaints versus student complaints? We used to have separate Title IX coordinators, but now I understand there is just going to be one coordinator now. Maybe talk about the pros and cons.
Great question. I would say that your read on that is right in terms of like there's been kind of more lumping together and even kind of a little bit of let me find the right word, challenging crossing over, as we were just talking about with Kim, right? Where depending on the parties, you might have a slightly different set of procedures, even for the same types of behaviors. So what I would say is, yeah, I would lump all sex discrimination and including sex-based harassment for whether it's employees, whether it's students, whether it's anybody. As a first step, I would lump it all under this document, which is your Title IX sex discrimination grievance procedures. So keep everybody together there. Now, within that, to what Kim was just talking about, you're going to have two kind of different pieces. You're going to have a piece that is for sex discrimination broadly, that is not sex-based harassment involving a student. So that would take in employees and stuff. And then you're going to have another piece for sex-based harassment involving students. And they're going to be slightly different. But for me, it's important that they're all in the same document. As in terms of like a Title IX coordinator for employees or a Title IX coordinator for students, I think you're right that I don't, at least under the new regs, I'm probably not a big fan of naming them as such necessarily. Like, we don't, because it's going to be the same document, the same procedures, we don't necessarily need to separate out in that way. Now, if you have the resources to do it, I kind of like having a Title IX coordinator and a deputy, and maybe one of those, maybe not on paper, maybe it's not like I'm for employees and I'm for students, but maybe one of those has a little more capability or experience in one versus the other in their background. And maybe in practice between the two of them, there can be like a division of labor that makes sense. So this person might step in more when you've got the employee complaints because of HR ties or experience, and this person might step in more with the student complaints. But in terms of having two named differently, you definitely don't need to. You don't have to do that, and it probably don't. I probably wouldn't.
Maybe if it helps, the way we do it at Wilkes, we have one Title IX coordinator who is our executive director of HR, but then we have a deputy Title IX coordinator who's primarily deals with student cases. So I don't know if that model would work for you.
I like that model. I think that's good. Yep. And then you just divide it. You take it case by case, right? Who are these parties? And who makes the most sense to kind of take point on this. I like that.
In the model you're proposing, how do you see any modification or change as far as the impact of legal representation for either of the parties?
Great question. Let me give it a thoughtful answer. I think that the both parties still get an advisor of their choice, right? Which can be an attorney. So let's start there. And that's why this is a great question, because that's still very much in play. But to your point, now it shifts a little bit, because in the live hearing before, in the model that was imposed on us under the 2020 regs, that advisor was coming to the table ready to ask questions on behalf of the party, ready to do like cross-examination, examination of witnesses. And in the model I'm proposing, that type of active role falls away for the advisor. So they can still have the advisor that's still legal counsel that can still be with them in meetings, but you can limit them as you do with like expectations and parameters on what they can do. And now, as I see it, they're not going to have that same speaking role. They're going to be more of an advisor saying to the party, hey, let me look over this evidence with you and help you suggest some questions that the investigator, the appeal officer would ask, but not doing the questioning. And so I would like to think it, I mean, every situation is different, right? But I'm a lawyer, and I'll say this about lawyers. I would like to think it puts lawyers back in the box a little bit in what could be a helpful way. You know, they can be there to represent their parties, but this doesn't turn into an adversarial courtroom type scenario that doesn't always work out the best.
Thank you.
Yeah, absolutely. Thanks for the question.
We still have about 14 minutes left. If somebody has a dire need to ask another question, you've got his attention.
Great questions, by the way. Appreciate it. Oh, I don't know if someone. Oh, I thought someone lobbed in another one. Trudy. No.
Tony wants to remind people to save the date. Title IX Student Conduct Symposium is scheduled for November 14th at Forsyth Technical Community College, and further information will be sent out in the next few months or so. So more information will be coming, but November 14th at Forsyth.
Nice. Good to see you, Tony. I'm excited for that. I've heard from people about that. People are excited about that. Good timing.
Yeah, I look forward to talking with you in the near future too, Josh. Good to see you again.
You too. And sounds great. Just give me a shout.
Well, got awfully quiet. So Josh, oh, wait a minute. Are live hearings required by the Fourth Circuit Court jurisdiction, state law, or another governing body policy that should be considered?
Really great question, because there's a lot of action. It's not just OCR we have to think about here, right? Like there's a lot of action in the courts around this. I've followed this closely. If anyone sees or knows of anything different or if something different comes about, let me know, because this is shifting rapidly with challenges, but not as of now. My read on it is that not as of now, as a school sitting in the Fourth Circuit, you have to do enough in terms of due process, right? That's why I suggest like allowing parties, even in this model, to suggest questions, to review evidence, but a live hearing is not required. And even in some states that are pushing the requirements further, a lot of those states or jurisdictions aren't going all the way to a live hearing. They're just requiring some kind of like a questioning mechanism. But for us, I think this model is sanctioned now by everybody who matters, right? Who can weigh in on it.
Josh, I do have a question. My understanding is everybody has to be trained, but the level of the training is different.
Yeah.
If you're a Title IX coordinator, you need more extensive training, like,
Yeah.
you know, a full blown out training. All staff and faculty have to be trained, but it could be just a brief overview of what sexual harassment is. Do you provide the trainings as well to colleges, or can you make recommendations for that?
Yeah, great question. Let me first confirm that you're right. The Title IX coordinator and the team, they have like a longer set list of things they need to be trained on, which is essentially how to do your job, right? And within the grievance procedures. And that's why I'm arguing for like a leaner team that gets deeper and broader training, because they have so much on their plate. You're exactly right that employees need training, but it's much more shallow. Like the broader non-team member employees, they need to know not to be part of the problem. They need to know that Title IX coordinator exists. They need to know above all about their reporting obligations, but that's much more shallow. I'm not Right now, I'm not doing active training. That's not to say that I couldn't under the right circumstances. If someone has a need, please call me and we can talk about it. Because I'm busy with some of the other things I mentioned, I haven't been doing active training, but I pair with people who do, and I can make recommendations to people who do. And if someone's in a pinch, I might be able to step in. So happy to talk about training needs.
Great.
Sure.
Thank you so much.
Yep.
That's very helpful. Well, I guess we're going to give you some time back. Josh, I so appreciate you, and it's so good to see you again. And thank you so much for taking the time today to go through, your proposed plans and, way to organize Title IX. I think you've provided some excellent information, and I hope people will follow up with you. It's been very helpful. And I appreciate the people that, had questions. And anyway, thanks so much for doing this, Josh. And please stay in touch with me, okay?
I will. My pleasure, Trudy. Thank you so much for the opportunity. Thank you, everyone, again for your time. Just great to be with you. I appreciate it a lot.
Great to see you. Thank you again.
All right. Take care. Bye-bye.